We are recording.
Thank you. Welcome to the Appellate Court morning session, March 4th, 2021. We are virtual. This is being streamed, live streamed on YouTube. Reminder to lawyers, please treat this as a courtroom because that's exactly what it is, even though we are all in different sorts of places remotely. And we judges will do the same. I would ask that everyone participating in the hearing of Estate of James Fry v. LOBBRUZZO et al. Introduce themselves, starting with the judges, then counsel for the appellant, and finally counsel for the appellee. I am Judge Alford.
I'm Judge Trial Referee Bill William Lavery.
And I'm Judge Cradle.
I am Mark Katz, the attorney for the appellant.
Abram Heisler, attorney for the appellee plaintiff.
Thank you. Counsel, prior to this argument, you received procedural instructions regarding this hearing. Do you have any questions?
No, ma'am.
No, Your Honor.
Okay, thank you. Please mute your mic when you're not speaking. We will try to do the same. I will be keeping track on my iPhone of the time. As always, each side has 20 minutes, and the appellant has the opportunity to reserve a portion of that 20 minutes for rebuttal. Attorney Katz, would you like to reserve from rebuttal time?
I'd like to reserve 5 minutes.
Okay. And I will endeavor to give you a 2-minute warning before your initial 15 minutes is up. You may begin.
Thank you. May it please the court. As your honors are aware, this is a summary appeal from a summary process eviction judgment. And the principal issue is the fact that the action was commenced by a fiduciary, Barbara Fry, in behalf of a decedent's estate, the decedent being the owner of the real property, which was the subject of the eviction action. I represented the 2 tenants in this single family residence.
Could I just interrupt you for 1 minute, Attorney Katz? Just procedurally, are your clients still in the property in Wilton?
They are.
Okay, thank you.
Thank you, Judge. During the pendency of the summary process action, a certificate of devise issued from the probate court devising title to the subject property to the 4 children of the decedent. Subsequent thereto, the then attorney representing the plaintiff fiduciary substituted the 4 devisees as plaintiffs and filed, after the substitution, filed a substituted complaint or amended complaint, which is and was the operative complaint at the time of trial and has been submitted to the appellate court in the appendix. And to be as succinct as possible, to my reading of the substituted complaint, there's no mention of the 4 devisees. And as this is a summary process action and specificity in pleadings is to a heightened standard, to my understanding of summary process law, the fact that the 4 devisees are not only not described in the substituted complaint, but their interest is not described. And in my opinion, that is fatal to the jurisdictional requirements in the housing court. And Judge Spader should have dismissed the complaint, or should have granted, should not have entered judgment for the plaintiffs, because there was no pleading, no allegation as to who they were, what their interest in the case was, and therefore the court had no standing to hear the matter. So that is the essence of the argument that I am presenting to your honors this morning. And I'm happy to address any inquiries.
It does not look like the judges have any questions, Attorney Katz. So you, of course, have your rebuttal time to respond, and any additional time to respond to anything raised by Attorney Heisler.
Thank you.
Counselor?
Thank you. May it please the court. My name is Abram Heisler. I represent the plaintiffs appellees in this matter. Your honors, as I've stated in my brief, I have 2 points to raise. The first is that the substituted complaint did, in fact, adequately describe the interests of the parties, and there was no undue surprise. The principles were the same. It was only who the underlying party was. But more important, the remedy of the defendants was to file a motion to strike if they felt that the wrong party was raised. Instead, the matter was tried, and the result entered. In answer to, if I could follow up on your honor's question to Attorney Katz, the defendants are in possession only because of extensive motion practice before the appellate court and the Supreme Court, and the closing of the courts for a period of time due to COVID. There was an order as part of the appeal. The defendants filed a motion to pay use and occupancy in lieu of bond as permitted by the statute. They have failed to make those payments since March. Their claim, when it finally got to court—
I'm since March a year ago, Mark.
Since March a year ago, that's correct. Since
And
March,
although they filed the motion.
yes, they filed the motion and paid for a long period of time. At the beginning of the pandemic, they stopped paying.
They stopped. Got it. Thank
Right.
you.
And this does have a tortured history beyond this case. Judge Spader granted the plaintiffs. I'm sorry, Your Honor.
No, go ahead.
Okay.
Go ahead.
Judge granted the plaintiff's motion to terminate the appellate stay based on it being solely for the purposes of delay. Defendants asked this court to review that decision. That, again, because of COVID, ended up taking a long period of time. They then petitioned the Supreme Court. They then, when that was finally resolved, they filed a second appeal based on their CDC affidavit, which is pending before this court now as well. So I would ask that Your Honors sustain Judge Spader in this matter. I think that from the record, from his written decision and also from his decision granting the defendant's motion, the plaintiff's motion to terminate the appellate stay, it's obvious that this appeal was wrongly brought and that the judgment should be sustained. If there's any questions, I'll rest on my brief.
I see no questions from my colleagues. Attorney Katz, you have rebuttal time if you care to use it.
Thank you, Your Honor. The order for use and occupancy was specific in that the use and occupancy was to be paid to the clerk of the housing court in Norwalk, which became impossible when the courthouse was closed due to the COVID pandemic. And no further relief was sought by the plaintiffs in the form of a modified order or new order as to the deposit of the use and occupancy. But the use and occupancy was faithfully paid up to the closure of the Norwalk courthouse. But what is more germane to this appeal is the whether or not there was subject matter jurisdiction in the housing court by virtue of a defective complaint, substituted complaint, which failed to describe the parties, the plaintiffs in interest, and their interest in the matter, and their basis or relationship. For instance, it didn't even go so far as to say that they were assigned or stepped into the shoes of their predecessor plaintiff, who was the fiduciary of the estate, or that they were the parties actually seeking possession of the premises. So it's not incumbent upon me or my clients to file a motion to strike if the plaintiff chooses to proceed on a defective complaint, that they do so at their own peril. And I cannot understand how the housing court obtained jurisdiction over a matter where the substituted plaintiffs are effectively not even described or mentioned in the substituted complaint. Thank you.
We have no questions. Thank you, counsel, for joining us this morning. We will now all leave the argument room.
Thank you, Your Honor.
Thank you.
Thank you.